court should have rejected that evidence, even if it had been timely submitted, because the evidence of student achievement is irrelevant in this situation.
Students who participated in the program had a 108% greater chance of graduating than those who didn't. It found in 2008, those who participated in the program passed the standard math test 144% more, the writing test 162% more, the reading test 168% more. The question is, in light of those statistics, is there anything that explains this other than the discriminatory animus?
The court should have rejected that evidence, even if it had been timely submitted, because the evidence of student achievement is irrelevant in this situation.
Why?
The state has plenary authority to set the curriculum for its public school students. The Supreme Court has recognized this.
That doesn't make it irrelevant. If it's demonstrated that a given program produces better results in terms of student achievement, and that program is outlawed, it would seem to support an inference of discriminatory intent if, in fact, educational attainment is more successfully attained, or education achievement is more successfully attained through the program.
The question here is, in fact, the state's authority to set its curriculum.
The state has the authority.
Yes.
But if the state rejects a program that's more effective in educating children, doesn't that suggest or strengthen the inference that the reason the state's acting is not because it wants to produce better educated children? This program does that, according to this evidence. It seems to me to strengthen the argument that the program or the state's regulation is intended with discriminatory intent to hold back a given group of the student population.
Good morning. May it please the court. My name is Erwin Chemerinsky, and I represent my RSA and the plaintiffs. This is the exceptional case where the state has violated those limits by a law that prohibits speech and does so in terribly overbroad and vague language. It's also a law that was motivated and that was implemented with a discriminatory animus against Mexican Americans. With regard to the First Amendment, the district court correctly found that Section A3 was unconstitutionally overbroad. A3 prohibits courses or classes that are designed primarily for minority students. All teachers try to engage their students. If a teacher had a class primarily of African American or Latino students, it would of course be expected to teach material designed to appeal to them. An English teacher with a predominantly African American class who chose to teach the works of Maya Angelou or Toni Morrison would run afoul of the statute. A music teacher who brought in rap lyrics or hip-hop to African American and Latino students would violate this statute. By the same notion, sections A2 and A4 are also unconstitutionally vague and overbroad. Section A2 says a course or class through resentment on the basis of race is prohibited. Last week, we filed for the court's judicial notice a letter that was sent by Superintendent Huppenthal on January 2nd, notifying the Tucson Unified School District that it's in violation. The example he gives in that letter was a question that a teacher asked about whether American slavery was particularly brutal. How then is it possible to teach slavery in a manner that might promote resentment based on race? How might a teacher teach about Ferguson or policing in the United States in a manner that might promote resentment on the basis of race? And Section A4 is particularly overbroad and vague. Section A4 prohibits courses or classes that advocate ethnic solidarity instead of treating pupils as individuals. I'm not sure what that means, but again, I would focus you on the examples where Superintendent Huppenthal a week ago Friday found that Tucson was in violation. One was a class that simply said it was going to teach hip-hop music. Another was a class that said it was going to look at Mexican and Mexican-American history. Does St. Patrick's Day promote ethnic solidarity at the expense of individuality? Does teaching patriotism?
Let's take the first one, which is not at issue here. Promote the overthrow of the United States government. Is Arizona allowed to enact that and enforce that provision?
Your Honor, I believe under Kieshin versus Board of Regents, this too would be unconstitutionally vague and overbroad, and I think that the amicus brief led by the Freedom to Read Foundation explains that. And here too, the example from Superintendent Huppenthal's letter is so important. Notice in his letter of January 2nd, the example he picks of what violates that is having lyrics from the group Rage Against the Machine taught. How could any teacher know that a single song would do that? And one of the key problems, Your Honor, is language is taken out of context from songs, from textbooks, and it is then used for violation. It's important to look at the exact language the administrative law judge used. The administrative law judge says this is going to be narrowed to instances where it is biased, political, or emotionally charged. Your Honor, I would hope that teaching at all levels is emotionally charged. I don't know how to teach about slavery or racism and policing that's not. And bias is so often in the eyes of the beholder. So the narrowing here is just as overbroad and vague. And of course, one of the problems with that is vague and overbroad laws lead to discriminatory enforcement. And that's what you've had here. So in answer to your question, Judge Clifton, this is both a facial challenge to the statute on overbreadth and vagueness grounds, and it's also an as-applied challenge, which includes to the administrative law judge decision. For indeed, as long as the administrative law judge decision is there, it too will have a tremendous chilling effect on speech of students and of teachers. The other key issue here goes to equal protection. To begin with, Horn campaigned for this law by saying Secretary Huppenthal campaigned for this law by saying that he wanted to, quote, stop La Raza. And you find that quote on page 1288 of the record. If you look at the dictionary, and this quoted on page 4 of our reply brief, La Raza is a synonym for the Mexican-American people. For a key official, both in the legislature and the Secretary of Education with regard to the law, saying we wanted to stop the Mexican-American people by this law, that clearly is enough to go to the trier of fact. But of course, that's not the only evidence of discriminatory intent in this case. When he was secretary, Horn said that 3 of the 4 ethnic studies courses created as a result of the desegregation order likely violated the statute, but enforcement proceedings were brought only against Mexican-American studies. Secretary Horn, before leaving office, found that the entire Tucson program violated this statute, and he did so following none of the procedures of the law. Under Village of Arlington Heights versus Metropolitan Development Corporation, not following proper procedures is key evidence of discriminatory intent. Of course, under Arlington Heights, discriminatory impact is relevant. 90% of the students in this program were Mexican-American. Notable.
What is it? What's the discrimination? I mean, it's not that there's not going to be education offered to Mexican-American children or that there's not education relevant to them. It's that particular programs shouldn't be offered.
No, Your Honor, the point is that the reason why the legislature adopted this, the reason why Secretary Horns and Huppenthal found violation was a discriminatory animus against Mexican-Americans. In fact, the district court specifically said Secretary Horns not following procedures raised, quote, sparks and red flags of discriminatory animus. We'd suggest it's much more than that when you look at the record here. It's also notable that when Superintendent Huppenthal took office, he commissioned his own study. That study, the Cambian study, found no evidence of violation of the statute, found that the courses were rigorous, and found that the courses were very effective. He then ignored the report and found his own violations. After that, an additional study was done. It was by the special master in the desegregation case, the Cabrera report. And what's so notable as you think about this is that both the Cambian study and the Cabrera study found that this course was tremendously effective from an educational perspective.
The school district abandoned the program, but the superintendent is still objecting to something?
Yes,
What's
the
the
Mexican-American Studies program was eliminated, but the law remains in effect. And I filed a letter last Tuesday in this court asking that you take judicial notice of a letter from Secretary Huppenthal issued January 2nd, 2015, finding that Tucson is currently in violation of the statute. That letter shows that this statute continues to have great effect, and that letter shows, better than any hypotheticals I could, how tremendously overbroad and vague the statute is. Rebuttal?
Thank you.
Thank you.
May it please the court, my name is Leslie Kyman Cooper, and I am here on behalf of the state defendants. The evidence to which my colleague referred regarding student achievement and the purported effect of these programs on student achievement. That evidence is irrelevant here, and in any event, the special master's study is not part of the record.
Broad.
Yes.
Designed primarily for pupils of a particular ethnic group. Why doesn't that by itself suggest discriminatory animus?
You need to look at the statute in its entirety. You need to look at the purpose as set out in 15-111. The legislature.
The statute, though, speaks in the alternative, right? These courses are prohibited if they fit 1, 2, 3, or 4, right?
Yes, they do.
Right. So why shouldn't we focus then on each individually?
You can focus, but you still must look at the stated purpose in focusing on each individual prong. And you must also look at 112E3 that specifically permits classes about the history of an ethnic group as long as they are open to and for all students. So we can have the teaching about an ethnic group. It's the divisive, segregative, separationist teaching for one group that this statute is designed to prohibit. It's the divisive, segregative, separationist teaching for one group that this statute is designed to prohibit.
But it does have subpart 3.
Yes, it does have subpart 3.
It doesn't speak at all about the content of the course. It simply speaks of who the pupils are supposed to be. And it's not hard to figure out that some classes are going to be more attractive to some people than others. I mean, nobody would be surprised that a Mexican-American studies program might attract more Mexican-American students. That doesn't necessarily mean the content of that program has to be offensive or contrary to the purpose you've set out, or the state has set out in another provision of the statutes. But this statute, 15-112, says you can't have a course that's designed primarily for pupils of a particular ethnic group. Well, the subsection you're referring to says classes that include the history of any ethnic group.
Yes.
That would suggest a class in Mexican-American history. Well, that's not just including, that's about that, and it's likely that most of the students that sign up for that will be Mexican-Americans, and that seems to run afoul of subpart 3.
I don't think that it runs a part of subpart 3 unless it is designed for the purpose of separating out those students and teaching a separate history that is not applicable to all the students in that school or that district.
So I'm maybe not following you, it may be my fault. What's an example of a course that would not violate 1, 2, or 4, but would violate 3, and therefore would be prohibited?
If you had a class that is designed for one ethnicity, for the purpose of separating them out, the Irish, the Germans, Jews, Asians, but is not about that group.
I'm not quite sure what you mean by for purposes of separating them out, unless you're talking about number 4, advocating ethnic solidarity. I mean, what Judge Tsushima said was he couldn't see what was prohibited by 3 that wasn't prohibited by the other provisions, and therefore it had the very great danger of either it was prohibiting something that constitutionally couldn't be prohibited, or it just invited overbreadth, invited vagueness because it served no obvious purpose. And I'm still not hearing an example from you of why that isn't true.
I think that you could have a class that was for an ethnic group that didn't necessarily teach ethnic solidarity that would be in violation of the statute. But if the court is inclined to agree with Judge Tsushima...
Well, what is that? You say there could be. I'm trying to imagine what it would be. And your cross-appeal argues that 3 should be reinstated. It shouldn't be struck down as overbroad. So you want that to be in the statute. Why? And what would that accomplish? And how would it accomplish something that wouldn't suggest discriminatory animus?
Well, the discriminatory animus that is alleged here is towards Latinos or Mexican Americans. And so if the class were for some other group, then the evidence that is offered here, of course, would not be pertinent to that. You could perhaps have a class in Japanese studies that would be designed solely for Japanese students, perhaps not to not advocate necessarily ethnic solidarity, but that would nonetheless be for them and not be about, and that would be a violation of the statute.
And what would be the state's purpose in enacting that?
Again, the state is concerned that all of its students should receive the same foundational education, should be taught as individuals, should not be divided on the basis of groups, such as class or race.
So if you have a classroom of students, some of which have commanded the English language because that's what their household has spoken their whole lives, and some of which who don't, and the fact that that differential is likely to be reflected in ethnic differential, the state of Arizona wants to make sure that the students who need additional help in English don't get it because they're going to be put into a classroom with people that spoke English from day one?
Well, there's a specific provision that relates in terms of English language learners, Your Honor. I'm not sure that I'm understanding your question.
Okay, well, try some other class. I mean,
supposing you had a course in the public schools of San Francisco in Chinese history. It was theoretically open to everyone, but lo and behold, in designing it, the designers said, you know, with substantial Chinese population in certain parts of San Francisco, we think this will be especially effective in helping Chinese students to understand their history. Is that, if that were in Arizona, would that be forbidden by the statute?
It could be, yes, Your Honor.
And why? How does that not suggest discriminatory animus? We don't want minorities to develop any kind of ethnic pride.
I don't know that there's a constitutional right to classes that would inculcate that ethnic pride.
But then you've got a problem with the potential inference that the intent of the statute is to make sure that certain groups don't emerge. Why isn't that something that could be inferred in the form of discriminatory animus?
Well, we need to look at the purpose of this. The statements that were made by the legislators at the time that this particular statute was passed, which was concern about a program that was divisive and separatist and took students away, that taught values that the legislators believed were antithetical to our constitutional values.
See, that I hear that as a justification for subparts 2 and 4. I don't understand how that's a justification for subpart 3 unless there's a broader animus against the minority population.
The court is, of course, to be guided as well by Epperson, the case involving the teaching in Arkansas of evolution. That's the statute that prohibited that teaching.
What makes this case different from what counsel just cited is this is a law that prohibits speech and in part is enforced by looking at what the student's speech is. A3 was properly found by the district court to be unconstitutionally vague and overbroad. It says if there's even a class that's taught that's primarily designed for pupils of a particular ethnic group, it violates the law. So if a teacher had a class primarily of African American students or Latino students and taught even a class to appeal to them, that would then violate the statute. You asked the question of severability. We, of course, believe that each of the provisions is unconstitutionally vague and overbroad. But it's important to note that there's no severability clause in the statute. And the question of severability is one of Arizona law. And in Ruiz versus Hall, the Arizona court said that the absence of a severability clause is relevant. The second issue is that this statute is unconstitutional, is violating equal protection because of the discriminatory animus in its adoption and implementation. I would just conclude with regard to equal protection by saying there's so much evidence here that indicates that there was a discriminatory animus, including eliminating a program that was proven to be tremendously successful. That's enough under Pacific Shores that this should have gone to the trier of fact. Summary judgment was wrongly granted and granted sua sponte. Thank you so much.
Thank you. We thank both counsel for your very helpful arguments. The case just argued is submitted.